So I come to my interest in the law with a lot of veneration and love. Now, to come to what the Chief Justice is trying to do, I am very troubled, not by her motives. I don't know her motives. I'm sure she means well, but by her awareness of the political situation we are. We are a few months to an election. We've had a lot of problems with our judiciary and its reputation. A lot has been done that has left a lot of bitter taste in the mouths of a lot of Ghanaians. And we can recite some of the decisions. The election petition, in which they wouldn't put Jane Mensah on the dock to talk, the shocking change of EC members with the connivance of the Chief Justice and other members of the Supreme Court, removal of Auditor General Domilovo. The perception increasingly that our judiciary, and particularly the Supreme Court, is biased, with warnings from Kandapa, who, even though an MPP member, expressed the worry of many people. Since then, other people have weighed in, former President Mahama, Mr. Opoku, who used to be Kufuor's security minister. All those people have weighed in, and 6 months to an election, all of a sudden, we hear that in a country that has 15 Supreme Court justices for a population of 33 million, compared to 330 million Americans with only 9 Supreme Court justices. We need more of them, and the Chief Justice doesn't even bother to follow the process laid down by the Constitution. I smell a rat, and I smell a rat because it will contribute to instability in the country. I think that our judiciary needs significant reform, but those reforms needed do not include just adding to the numbers of Supreme Court justices. If the work is too much, the court, or for that matter, Parliament, more appropriately, should look at the U.S. Judiciary Act of 1787 and 89, which set out the parameters of the American judiciary. The first thing, for example, is that we should cap the number of Supreme Court justices. Second, we should define the appellate process, including the picking of panels for Supreme Court cases. We should bring more transparency. And by the way, our Parliament can do a lot of these things that have the Constitution is silent on, and it will bring a lot of stability to our judicial process. I am very worried about the reputation of our judiciary and where we are leading it, particularly in the teeth of an election that is only a few months down the line.
Right, so you just raised the comparison with the Supreme Court of the United States of America, which caps its judges to the apex court at 9. Now, there is a factor you will be urged to consider and see if the comparison is a good one. In the US, you have a federal system of government that is practiced. Each of the 50 states has a Supreme Court, with the exception of Oklahoma and Texas. These have the 2 Supreme Courts, one for civil and the other for criminal cases. So if you check properly, the total number of state Supreme Court judges throughout the United States of America is 344. What do you say to that? No,
what I say to that is that
and again, as you try to advocate, their jurisdiction is narrow. The Supreme Court of Ghana's jurisdiction is wide. I was trying to calculate with a friend of mine, Dennis J. Jumo, of Dennis Law, and we were counting as to about 9 different jurisdictions. Some people have counted 7, some have counted 8 jurisdictions, but in the pure sense, about 9 different jurisdictions. Elsewhere, they have just the appellate jurisdiction, and even that you have to come by leave. That means that not everything goes to the Supreme Court. Like in South Africa, they've also capped it, I think at 11 or so, but they have a constitutional court. And then they have the Supreme Court constitutional, they have the other one for appellate jurisdiction. So what will you say about that? In terms of the numbers, that was my first question.
Sure. There's an interesting question, but if you study the evolution of the American judicial system, it was not always like this. From the Judiciary Act of 1787 to be the Supreme Court to rise circuit, in which, apart from deciding Supreme Court case, they served as judges who rode around deciding cases. So the system has evolved. And eventually, part of why their jurisdiction and their work load has become manageable is what you alluded to, granting certiorari. Granting cert means the Supreme Court doesn't have to take every case. For example, you need to obtain cert to have 4 of the 9 Supreme Court judges agree to hear a case. So every year they hear approximately about 70 cases that they think portray conflict from the appellate courts, or questions of original jurisdiction, things that are important in law. For example, this year they talked about the Chevron. Having said all that, I just say all this to say that there are ways that you can make our court system more efficient, and I've mentioned some of them. Clear and transparent appellate process, having timelines in the decision of cases, granting certiorari so that the court doesn't have to take all cases. So there are ways of dealing around that, but I take your point that there has to be some refinement. But having said that,
and you raise an important point that they sit at the beginning of the year to determine the number of cases they will do, and you say they will take 70 cases in all, for example. What will you say if you heard that our judiciary, our Supreme Court, in these years, in 2018 and the 2019 year, they were saddled with 761 cases. In the 2019-2020 year, they were saddled with 896 cases. In the 2020-2021 year, they had 906 cases to deal with. 2021-2022, 799, and then the very 2022 and this last year, 939. And in all these, they managed, out of the 761, they were able to conclude 559. Out of the 869, they managed to conclude 653. Out of the 906, they did 694. Out of the 799, they did 385. And then finally, out of the 993, they did 344 cases. And in all these situations, doing with less than 15 judges. In some situations, 12 judges. Only at one instance, they had 18 justices, which quickly reduced to 16 justices.
Samson, efficiency. First, if you look at prioritization, for example, regardless of whatever caseload you have, the Domilovo case should have been heard quicker. And I think the delay was not because of workload. It was because of judicial politics and the fact that there was an audit of the Supreme Court that had bad findings they didn't like. Secondly, the US Supreme Court in Bush versus Gore decided that between the month between, say, December 7th and what do they call it, January 5th, when they had to go and do the ballot counting, they had decided it in a month. Look at how long it took us to decide the two presidential election cases. They went on interminably. So part of it is inefficiency. We can make these things more effective. If the US can decide a presidential case in 2 weeks and Kenya can do that in relatively short term, I don't understand why we can take months and almost get into a year. That is inefficiency. So the other reforms would obviously speed up. And then the other things is also that we should allow more of those cases to be determined by courts that are lower than the Supreme Court. So having said that, yes, I get all the case laws and all that kind of thing. I'm talking about intent. And when I'm talking about intent, I'm also talking about reputation. That, for example, when you look at the US Supreme Court, their reputation has changed. It's been low and up depending upon the nature of the cases they decide. You know, when you look, for example, at Dred Scott, you look at Plessy versus Ferguson, they were very badly decided cases. Then when you come to more good things like Brown versus Board of Education and others, then their reputation improves. So I am saying that it is an unfortunate time for the Supreme Court to make a case for more help because their reputation is getting down and the public is not supportive, even if some of the case they are making is valid. And part of it is from self-inflicted wounds. I think that it is very difficult, regardless of her motives, for anybody to look at what the Chief Justice is deciding to do 6 months to an election in the context of the warnings by Kandapai and John Mahama and not think that this is a blatant attempt to pack the court.
Okay. And I mean, listening to you and lawyers listening to you, they will endorse the facts that you narrated earlier about what your teacher said you should have been doing, because some of the cases that you know, it's only law students who are familiar with them. The Kofi, so I think, Dr. Kennedy, first to you with this questioning about efficiency. We understand the conventional average that you have on the Supreme Court has been 15. In fact, in 2016, when the Ghana Bar Association took a suit to the Supreme Court, challenging how the president had gone about an appointment of judges, I think that was Spwamang and Apau, there were issues. The Supreme Court in that decision actually has said that the court had never exceeded 14. I suppose that meant without the CJ. By the architecture of our Constitution, there are supposed to be 9 justices, CJ inclusive, a maximum of 10. But the court can do its business with 5, it can do with 7. There have been circumstances where there's a need to empanel 9. What do you say when you hear this? That conventional average of 15, only 2 panels of 5 and 7 justices or 9 justices can be constituted. This tends to exhaust the entire number of justices of the Supreme Court on a sitting day. So you have had the challenge of sometimes where you have recusal of justices. Maybe a judge has been involved in a matter before, so he comes to the Supreme Court. The judge was in the Court of Appeal and deal with the matter in a certain way, and then they have to recuse themselves. And the number continues to go down. And then there is a frequent situation where some of the judges, because they would have, like I just mentioned, dealt with these matters, they have to recuse themselves. And then also you have the ripple effects of the disruption of what we call pre-sitting conferences. The CJ has to constantly be reconstituting the panels because they are not getting the sufficient numbers to do what they have to do. So don't you think that it may be necessary for efficiency to have good numbers, to have at least 20, which is where, if these 5 are approved, we will get to. They will add to the 15 to make 20. If they add to that, then it means you can have at least 3 separate panels at any given time so they can deal with the cases. What do you say?
No, I don't. I'm unimpressed by that. Let me tell you why. The Chief Justice has sometimes moved judges around when cases have been heard and they are on the verge of delivering judgments, which have led to restarting the cases almost de novo. If he was trying to promote efficiency, he wouldn't do that. An example is the Commonwealth versus Legon case, where a judgment was about to come in a week and then she just reassigned the judge. If you were trying to promote efficiency, you wouldn't do that. I also think that when you talk about the 9 judges and then the Chief Justice, it is a flaw by the Constitution. It means that nobody knows the ceiling. I think that when you don't have a ceiling to the number of judges you have, there can be a lot of judicial opportunism. And we're about to see that. For example, when we nominate these judges, like the ones you have on the table, is it because they are the best judges around? Is it because they are loyal to somebody? Is it because they are somebody's friend?
My understanding to that question is that there are judges who have been identified as those that within the fraternity, the lawyers can confirm are judges who have speed in the way they do their things.
Yeah, but justice delayed is justice denied, but is speed always the best quality of a good judge? I have also heard judges who have different opinions about this one, but I'm just saying that these things require broad consensus within the legal community as well as within the political community. Appointing judges is a political process. As they say, a judge is a lawyer who happens to know the president, and we should also not be ignorant of charges that the courts are being packed. And it is very difficult to look at this situation objectively 6 months before an election and think that there are no political motives to this attempt to introduce more Supreme Court judges.
Please hold on there for me. Yes. Yes, conclude. I wanted to come to Rickett Hagan, and then we'll come to you finally later.
Sure. So I just think that the way this thing is being done, it lacks transparency. And as I have said repeatedly, we just don't have to focus on the Supreme Court. I think our whole system of justice needs radical reforms that will lay out clearly a time-dependent appellate process, transparent empaneling of panels, consistent panels that are not changed at the whims and caprices of the Chief Justice. I can tell you confidently there are Supreme Court judges who don't understand some of her motives for changing panels and are very unhappy.
Okay.